All right, everybody. Well, welcome to Strategic Civility in Family Court, turning opposing counsel's bad behavior into strategic advantage. I am Ryan Wedeking, co-chair of BHBA's Family Law Section. Family Law Section is sponsored by White Zuckerman, Lawyers Mutual Insurance Company, SoberLink, and Our Family Wizard. White Zuckerman provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Learn more at wzwlh.com. SoberLink provides objective real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases. To help ensure smoother negotiations for a more efficient legal process, consider using SoberLink's trusted alcohol monitoring system to eliminate hearsay and protect your client's best interests. With an unprecedented combination of features, including advanced reporting, facial recognition, tamper resistance, real-time results, and customized testing, the discrete system has been the leader in remote alcohol monitoring since 2011. Learn more at soberlink.com. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that Lawyers Mutual is directed by a group of dedicated lawyers. They offer special rates with competitive premiums for a wide range of practices, including family law. Learn more at lawyersmutual.com. Last but not least, Our Family Wizard is a co-parenting platform designed to help families communicate more effectively, to reduce conflict, and to create reliable court-admissible records. Features like tone meter, AI, shared calendars, expense tracking, and in-app audio and video calling help support compliance and better outcomes for families navigating custody matters. I will note that our family law section meetings are held on the third Wednesday of each month. So our next BHBA Family Law Section meeting will be held on Wednesday, July 22nd. Those meetings begin at 4:30 p.m. It's a great opportunity to kind of get the state of Department 2. We hear from Judge Kaufman. You will also hear from a leading family law attorney on what we call our family law tidbit, which is like a 5, 10, 15-minute CLE on a topic each month. So it's a great opportunity to network, to learn the latest down at Department 2, and to maybe learn a little bit each month with a group of your peers. So we invite you to join us for our monthly family law section meetings. And if you can't make it, send an associate. It's important that your firm is up on the state of the art. So with that, I'm delighted to introduce our speaker, Noel Guth. Noel Guth is a California civil litigator and founder of the law offices of Noel Guth, PC, practicing family law, estate planning, personal injury, medical malpractice, and mass tort litigation. She is licensed in California and Washington, D.C., and all of California's federal courts. She's been named a Daily Journal top family law attorney for 2026 and a Best Lawyers Ones to Watch honoree since 2023 across 6 practice areas. She writes a monthly family law column for the Daily Journal and practices statewide from Yuba City in Sutter County. Now let's get started. Noel.
Noel, it does look like your audio is a little bit out for a second. Can we try to adjust the microphone again?
Yes. Does that help?
Can you say a sentence for us, please?
My name is Noel Guth, and I'm honored to be presenting today.
Perfect. All right, let's try. All right. Let's see. Here we go. All right. Looks like we should be ready to go.
All right. Good afternoon, everyone. I would like to thank the Beverly Hills Bar Association for sponsoring this CLE this afternoon. And I would like to thank all of the attendees for spending your lunch hour with me. This lecture this continuing legal education seminar is going to be a talk on strategic shift. This is not an ethics lecture. So we will dive into ways that you can shift your practice when opposing counsel is not acting in the most civil manner, and streamline the litigation for your clients so that everything proceeds effectively, cooperatively, and as cost effectively as possible. So I'd like to start by saying what used to look like zealous advocacy in the courtroom years ago now reads to the bench as poor case management. We're going to talk about what we as family law practitioners can do about that. Can you move to the next slide, please? So the first slide is just some background on myself. You have already heard that. Again, my name is Noel Guth. I am the founder of the law offices of Noel E. Guth PC based out of Sutter County, California. I do work remotely on a statewide platform, so I have worked in virtually every jurisdiction in the state of California and have a lot of experience in those courts. Today's discussion is adapted from an article I recently wrote and had published in the Daily Journal, explaining how civility is such an important area that is often overlooked, not only by family law practitioners, but by legal professionals in general, and how that can have a negative effect for your own clients, but also on the court system overall, and shift the perception that the judge handling your case has not only of you, but the emphasis that the judge will put on whether or not to hear motions or fully read pleadings in the future. Unfortunately, when judges get high volumes of emails and motions being filed, at the outset of matters, it can affect whether or not the judge spends the time on your filings in the future. So we want to ensure that from the outset of the case, we are doing everything in our power, one, to be civil, but two, enlist the court's help to put procedures in place to really streamline cases and ensure that we are acting in a civil manner, but also that opposing counsel is treating us as such. Next slide, please. So by the end of this hour, you will be able to recognize the judicial shift in civility. Most judges have come from areas that aren't necessarily a family law background, and it's showing in the way they are hearing and adjudicating cases. Most have little tolerance for gamesmanship, and they do not want to deal with counsel on either side of a consistent bickering back and forth. Number two, we're going to learn how to use the toolkit that's available to us. Case management orders, early stipulations that you can reach with opposing counsel on issues, early mediation to flush out the real areas of contention, joint statements, the list goes on as to what's available to us to effectively streamline those cases for our clients and ensure that there's just no room for muddying the waters or incivility. Number three, I want to teach you how to respond strategically when you have someone on the other side who is not the most civil towards you, whether that be in emails, in phone calls, or in filings to the court. And the last one, this is very important not only to protect yourself and the oath that you've made to the bar administration, but also to protect your client, because they are the ones that really suffer when there is incivility on either side of a litigation. Next slide, please. So as you can see from this slide, there are generally 2,000 filings per judicial position in California courts. Many of you will see that filings are weeks behind. You'll submit them to the court. You're not getting things filed stamped back, sometimes 2, 3, 4 weeks. And that's just because the caseloads are so large. That gives you a little bit of perspective on what the judges do and do not have time for. They do not have time for gamesmanship. When you forget something or opposing counsel has not planned something out well, it's not an emergency for the court to address it. It may be for us and our clients, not only for malpractice reasons, but also family law is very high anxiety, high energy. Everything is an emergency because you're dealing with someone's life, very intimate parts of their life, their children, their marriage. And so they want things done on an expedited basis, and that's not always possible. I want you all to keep in mind that the efficient attorney wins the room. And what I mean by that is if you are well organized, you have CMOs in place to streamline discovery issues, incivility, bickering back and forth, superfluous motions being filed, the judge will look more fondly on you and be more willing to accommodate your position in court. And then keep in mind that sometimes clients will want not only the most zealous advocate, which we have an opportunity to be, but they also want that bulldog in the courtroom, which is great in a lot of instances. But sometimes winning can cost you the war. And what I mean is filing a motion that you know you're going to succeed on just to get the win and prove a point isn't doing the best for your client. It's costing them time, it's costing them money. So if we have procedures in place ahead of time to be able to avoid that motion practice, you are doing the best job for your client, and the court will appreciate that. Next slide, please. So what counts as bad behavior from the bench's perspective? As we all know, a lot of times family law clients cannot, or family law case participants cannot afford legal counsel, so they proceed in pro per. The judge is not supposed to, but they generally do treat pro pers differently than attorneys. Pro pers don't have a great idea of what is required of them. Oftentimes their filings become very accusatory, attacking, and they will undertake motions and things that just waste the court's time. It's very important when you're dealing with a pro per on the opposite side that you at the outset set expectations and boundaries and try to put stipulations in place to really streamline what needs to be done, have a clear planning of the issues that are before you, and you can really gauge whether or not this person is going to be incredibly difficult and adversarial and fight you on every turn, or if they are going to be cooperative. I had a recent case where husband originally was represented by counsel, was non-responsive to her. She filed a motion to withdraw. The matter went to trial. We got the orders, but then he refused to sign the judgment documents. He refused to overturn paperwork we needed turned over in order to have his pension divided. His emails were quite vile, to the point of saying, you know, your emails mean nothing to me. I laugh when I read them. There's nothing you can do to force me to do this. Well, I quickly addressed that by very kind emails back to him explaining his obligations, then was able to attach those to a motion showing just his deliberate refusal to actively engage, have an LSOR appointed by the court to sign off on documents and pretty much proceed without him. So by creating that track record of being cooperative, being the one that is conciliatory whenever he is trying to kind of ruffle feathers and not engage, to get orders in place from the court that not only required him to participate, but when he wouldn't do so, had someone else step in and allowed Moon, Schwartz, and Madden to prepare the quadros, allowed me to send them off to CalPERS. I was able to quickly resolve this for my client in a situation where that would not have been possible otherwise. Often attorneys are judged more harshly by judges because we should know better. We went to law school. We've all had moments where we've wanted to fire off a nasty gram to someone on the other side because what has been written to us is just oftentimes very horrible and vile. But you need to sit there and really think, is it worth it for you to actually send that back? If you need to take a break, type it out in a text box on your computer, save it for yourself. There was your vent. Never ever send them back. Remember, everything that you send to opposing counsel or anyone in your case besides your client is ripe for the taking before a judge. And always write your emails and respond with professionalism, cooperation, and kindness. Opposing counsel could have been having a bad day. That could just be their personality. But you want to be as cordial as possible and keep the court on your side. Next slide, please. I do want to remind everyone that as of April of this year, we all signed an oath to the court saying that we would act with civility. If you did not check that box and sign that document, your bar admission has been temporarily suspended until you do sign it. So the court and the bar is looking very closely at whether or not we act with civility towards one another, to opposing counsel, to pro pers, and to our clients. So please, please keep that in mind. Courts are becoming increasingly aware that incivility is becoming a money issue for our clients as well. There are 2 recent court decisions that have reduced attorney fees for attorneys where they have found the attorney acted incivilly. And so it's very important that we keep that in our minds. Years ago, the playbook was aggressive, vitriolic correspondence between counsel. You were there to fight it out at all costs and do everything you needed to win for your client. Several last-minute ex parte applications, so you would catch opposing counsel off guard and they wouldn't have time to prepare and respond to your motions thinking that was a win. Lots of gamesmanship in discovery still happens. Hiding the ball, a lot of that has been addressed by discovery rules requiring us to clearly organize pleadings, to be sure that we point out documents that are directly responsive to what's being asked of us. Sometimes you still get the blurbs of non-compliant discovery, but that is no longer typical in court. A lot of times Family Court 271 sanctions were more readily available in the past. Now judges are not so inclined to grant them because they find that ordering 271 sanctions actually can frustrate the settlement process further. So you are less likely to get 271 sanctions at the beginning, middle of the case. Sometimes you can get them at the end. I'm finding more likely than not you don't get them at all. Now, the strategic response to that traditional playbook is to always prepare a professional and concise written record. Like I said a moment ago, everything that you send is ripe for turning into the court. Keep that professional, cooperative, because that is an advantage to you and your clients. Plan your case management up front. Within a week or 2 of dealing with opposing counsel and knowing the issues before you, you are going to have a very good idea of what opposing counsel is like. If you've never worked with them before, if you're able to clearly point out issues that you can work together on at the outset to get those out of the way for your clients so that those big picture issues that are more difficult to address have the forefront and take up most of the case. We're not fighting at the outset of who's going to get which car, who's going to pay for A and B when parties are already driving them. That's already been resolved for now. We'll deal with that later. I highly recommend early mediation for issue framing. Because of the mediation privilege, you can go into a mediation or any sort of ADR and you don't have to worry about your thought process being disclosed or used against you later on, but you can really use early mediation to pinpoint where the areas are that you need to spend the most time, not only with your client, but areas that you can also quickly wipe off the table with opposing counsel. I highly recommend early mediation, or at least some sort of early mediation type briefing that you can exchange with opposing counsel, because it is going to streamline your entire case and help you move through issues much more quickly and cost effectively. I recommend that you do not seek those 271 sanctions or other sanctions right off the bat. Be very strategic of when you ask for sanctions. Motion to compel, where they're pretty much guaranteed to your client, are great examples of that. Do not ask for sanctions that are highly up to the court's discretion. You are very unlikely to get them these days. Go for sanctions where the statute says shall instead of may. That is going to be your guide of whether or not to ask for sanctions early on. If possible, try to bifurcate issues. That will reduce conflict pressures as you go forward. And that's really going to help you, again, move your case forward in the most effective and civil way for your client. Here, I want you all to be aware that civility is a power move. Civility is tied to fee reasonableness. That was the recent decision in Carton. There is an unpublished SNEC case that says lack of professionalism is a lower showing of skill for attorneys. You want to be professional, you want to be as zealous as you can, but do it in a kind and cooperative way. There are 3 recent cases on this. They were 3 different angles, but they all have the same message. The bench has been told and is acting on the idea that civility is professional competence. Please keep that in mind. Those Carton and SNEC decisions that I just cited flip the old assumption, this old traditional playbook before us. We used to assume aggressive lawyering meant higher fees were justified. Now appellate courts say just the opposite. Next slide, please. So we can zoom through this slide. This is not another 271 talk. As I said, courts are not inclined to give 271 sanctions as freely as they used to be. So I recommend following the methods laid forward in this presentation rather than diving for those first. Next slide, please. So oftentimes, being aggressive in court can backfire on us. There are often red flags that annoy the bench, such as serial requests for order filings on overlapping issues. When you file requests for orders, make sure they are clear and intentional. When you file a response to a request for order, don't use that as your opportunity to ask for everything under the sun for your client. File your own requests for orders on specific issues. If you cannot meet with opposing counsel and resolve them at the outset, be very strategic in what you ask the court for relief on. Please do not file excessive ex parte motions without true emergencies. I have dealt with opposing counsel where anytime she didn't get the answer from me that she wanted right out of the gate, within a day or 2, I was getting served with notice she was going to be filing an ex parte motion. When no true emergency existed on the issue, there is a time and a place for ex parte applications, and weekly filings are not it. Again, vitriolic correspondence and back and forth bickering with opposing counsel is not going to win you any fans, especially not from the judge's bench. Do not threaten 271. It's likely not going to get you anywhere with opposing counsel, and more so with the court. Do not lead into the hide the ball, discovering objections just to make objections. Be very, very clear and intentional about what you're objecting to. A lot of times, even if you object, it still requires a response because you likely have information or documents that are responsive. Do everything you can at the outset to try to get that discovery released. Otherwise, it's just going to create a delay and motion practice that could have been avoided for your client. Please try to plan your filings as much as possible. We all have very heavy caseloads. Things sometimes can get lost in the weeds, but if you really sit down at the outset of your case and flesh out the issues, you can have a pretty good timeline before yourself that you can adjust to know what you need to file and when, and preempt what might be filed by opposing counsel to keep the process running clearly, smoothly, and kindly. Next page, please. As I mentioned earlier, civility is now required. We all signed California Rule of Court 9.7. We state, as an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. Every active licensee must annually declare and adhere to this oath language. Enforcement began April 1st of this year. Like I mentioned, attorneys who failed to file this declaration get rolled as inactive. This is a real consequence, and we should all take this new oath very seriously. Next slide, please. So here are 3 cases that I mentioned earlier. Excellent Carton stands for the proposition that excellent lawyers are civil. SNEC is an unpublished decision, but found lack of professionalism is a lower showing of skill by attorneys. And Reid versus Google told us all to focus on the objections that really count. In that case, the California Supreme Court encouraged parties to raise only meritorious evidentiary objections or face informal reprimands or formal sanctions. That is something that you really need to be aware of. Over-objecting is its own liability, not only to you, but to your clients. Civility is credibility. Credibility is persuasiveness, and persuasiveness is getting what your client wants. So what do you actually want to do with this in your next case? Next slide, please. So 5 tools that you can deploy before and instead of that 271 sanctions motion that's not going to get you very far. 1, case management orders. 2, early mediation. 3, joint statements of issues. These are really, really helpful. Anytime you can do a joint statement with opposing counsel, 1, you're dividing the work, but 2, you really get a good rapport with opposing counsel and can flesh out what needs to be focused on, not only for your client, but for the case as a whole. 4, bifurcate where possible. Diffuse those worst issues first. And 5, keep your evidentiary objection protocols reined in. Every one of these is a tool you can deploy today. The law is already there. What's new is being sure that you use it deliberately. It's not always an intentional practice, but I hope you will make it one. So let's start with the most important one. Next slide, please. Case management orders. These are your biggest tool. If there is one thing you take away from today, this is it. Case management orders. A lot of family law attorneys don't ever use these. Case management orders are used all the time in larger litigations. Multi-district litigations, for example, there could be hundreds of case management orders. They are a really, really useful practice for you to set timelines in place that are ordered by the court. Oftentimes, the courts won't assist with how you manage the cases going forward. If meet and confer deadlines are set, when witness and exhibit lists need to be exchanged, whether or not you do individual or joint statements of issues before hearings, you can ask the court to order you to do all of this. If at the outset of your case or early on, even in the middle of the case, if you find opposing counsel is just becoming increasingly difficult, first try to reach stipulations with opposing counsel. I sent an email last week, for example, where it was uncovered that father in one of my cases has a pretty severe mental health background that he was not forthcoming about. The only reason I was aware of it is because I asked all of my clients at the outset of Family Matters to download all of their text message history with their spouse. I have them send that to me. Usually, if they have iPhones, it's a program called iMazing. They have a similar platform for Android devices. but it clearly downloads every single communication in reverse chronological order. They are in a format that you can use as exhibits, and I read through them. In reading through the history of this client's exchanges with her estranged husband, there were things said that were very obvious mental health flags. Husband admitting to alcoholism, that wife necessarily wasn't aware of. Husband admitting to some suicide attempts that wife hadn't witnessed, but they were all in his own words. What I was able to do was pin cite those communications to opposing counsel. This dissolution's only been pending about 3 weeks. Point out to him, you may not be aware of this. This is a clear safety issue for the child involved. I know we both have that child's safety at the forefront. Before this becomes evidence for the court, or it has to be brought up in family court services mediation, because as most of you know, most courts ask, are you aware of any mental health history of opposing party? Are you aware of any substance abuse history of opposing party? And your clients are supposed to answer that honestly. Instead of putting that all before the mediator that can be put then into a recommending mediation report and get before the court, you can send emails to opposing counsel, as I did, and say, can we put these stipulations in place? Here's 1 through 5 that I propose. Husband, father remains in therapy. 2, he enrolls in SoberLink. 3, he does a check-in on every visit after the child goes to bed so that we can be sure he's sober, something of the like. And I was able to get father to agree to 3 of the 5 terms that I proposed. And we have some really strong safeguards in place already for visitation. And this hasn't even gone to mediation yet. So the mental health and substance abuse doesn't need to go before the court for any adjudication. And the parents are collaboratively working together through counsel to put custody and visitation in place, where that could have been a very nasty battle before a judge. That issue's already off the table. You have a lot of options, and you can get very creative on what you can ask the court to do for you. If you have already gone through one round of discovery and found you are just not getting the answers you want and it's evidence you're not going to, lead with a CMO on a discovery schedule with enforceable dates. That way you can move quickly towards evidentiary-based sanctions if necessary, because you already have the order in your hand that says what you have to do by what date. This eliminates that last-minute gamesmanship and gets you what you need quicker and more cost-effectively. You can issue sanctions warnings through the court under 2 code sections, both 177.5 and 271. Once you get those warnings tied into a case management order, you have built the record for later if opposing counsel's compliance fails, and you are much more likely to get those sanctions under those code sections than you would have been ahead of time because the court has already made them orders. So I bring a proposed CMO to almost every contested case now. Even if the court doesn't adopt it verbatim, I've anchored the discussion and let opposing counsel know that I'm serious in how I'm going to address these things going forward. I want you all to know that the materials packet that you've been given has sample CMO language that you can adapt to your case. So whether or not you have a CMO yet, mediation can do real work for you early. So I want to address that topic next. So let's move to the next slide, please. Early mediation. So mediation is no longer just a settlement vehicle. It is a case management vehicle for your client. It has 4 purposes: discovery framing, issue narrowing, a safe place for you to vent, and it shapes your client expectations. A mediator who knows the bench can deliver hard truths to your client more credibly than you can. Use that to your advantage. Oftentimes our clients now are running to ChatGPT to see their success on things. Or, I talked to my friend who went through a divorce 5 years ago and this happened for them, so they assume that's what's going to happen in their case. As we all know, very unrealistic that what ChatGPT says or what their neighbor did 5 years ago is going to pan out in their case. If they hear it from a retired judge, for example, or another neutral, they are much more likely to believe them and take you more seriously later on, and they'll have more clear expectations of their case going forward. A realistic mediator can calibrate your clients in ways that we just can't. Judges often offer early mediation or will grant it if you ask for it in a case management order or through a request for order. Next slide, please. So whether or not you mediate, please always make your disputes crystal clear to the judge. Do that very clearly through a joint statement of issues. You want to force specificity from opposing counsel. You want to clear those boilerplate filings, and you want to narrow the fight for your client. The vague version of what you need from the court is support is at issue. We've all written this. Stop writing it. Support is at issue in almost every family law case. The court knows that. What about support is at issue? Please be specific. List those discrete disputes. Income calculation is going to be a problem. There's an imputation issue here. The duration of the marriage is iffy. One party saying A, another saying B. It was very close to 10 years, but not quite 10 years. Whether or not there's bonus income that needs to be considered. If the bonus incomes needs to be a true up later on. All of this are things that should be pointed out very clearly to the court at the outset so that you, as the practitioner, can shape what needs to be done. Opposing counsel is aware of what you plan to address, but the court is clear of it very, very early on. Next, this forces specificity, creates accountability, and often becomes the settlement framework. Try to include a joint statement of issues requirement in your proposed case management orders. The joint statement of issues and the case management order will reinforce each other. Use them. They're symbiotic. It's to your advantage. If opposing counsel seems that they would never agree to this, file a unilateral statement of issues for the court. If they refuse to engage in a joint statement of issues, the court reads that too. You've tried to be collaborative. You've tried to work on this, and the court will be aware of who's on the side more likely to resolve things, who's on the side more likely to make it more difficult for them, and that will work to your advantage. It, one, builds credibility with the judge, but two, the judge will come to your case from then on with a different lens. They may be more inclined to focus on pleadings that you file that are much more clear, whereas they are not as clear and more vitriolic from opposing counsel. Again, that is two tools that you can use to move your case along faster. Next slide, please. Tools 4 and 5, again, kind of go hand in hand, your bifurcation and your evidentiary objection protocols. So bifurcation. These are where we're going to separate contentious issues for sequential resolution. Early on, bifurcate status from property division, bifurcate custody from support, bifurcate valuation date disputes early, and use partial progress on those issues to build settlement momentum. You can never decide property division without determining status. You can never resolve support without knowing who's going to have custody. Most know bifurcation. It's very, very underused. Diffuse your worst issues first. Again, status, custody, valuation dates. Status bifurcation is psychologically powerful for our clients. Once your party is single again, their emotional temperature drops. They are more likely to want everything else to be resolved because they already have their single life. They are working towards moving on. That's going to make things easier for you, for your client and for opposing counsel. Your evidentiary objection management. It's newer. It is less familiar to a lot of practitioners and especially their clients. Some courts now order meet and confers on objections before the court will rule. It's required under a lot of statutes. So please try to do meet and confers early on. Try to stipulate two things with opposing counsel as much as you can. It's going to get you a lot farther than contested motion practice. The certification under penalty of perjury feature in evidentiary objections is what gives them teeth. So now let's see what this looks like when you actually face a hostile situation. Next slide, please. Here is a hypothetical. Let's take a minute to pause and read this scenario together. Opposing counsel representing party A sends snarky, aggressive emails, refuses to meet and confer in good faith. Party A has filed numerous overlapping requests for orders. Let's walk through our very strategic response. Next page, please. So here's what I do and why. This is 4 moves in order that will reset your case. As I mentioned early on, hold the line in writing. Respond to snarky or vitriolic emails with professional, concise, and factual correspondence. Every reply is evidence. Make sure your correspondence helps you and your client. 2, document the obstruction. Always create a clear paper trail of good faith meet and confer attempts, unanswered correspondence, and specific requests that have gone ignored. I now build a timeline for myself early on to where I can track. I'm not going to remember every email. I print them. I create my timeline and they go right into a dated file. So I can quickly reference in the event that I need to file a motion. I have it all at my hands. Then file a request for order that includes a proposed case management order. Attach a detailed proposed order. Set forth the meet and confer requirements that you need, whether or not you need those joint statements I discussed, a discovery schedule, an early settlement conference. Anything you can do to get orders from the court will benefit you down the line, and it will benefit your client and save them a ton of money. The last step is to frame what you're doing as a solution, not a complaint. A lot of times when opposing counsel feels like you're attacking them or the way they've practiced, the way they've been doing it for 30, 40 years, or 5 if they're newer, they don't like feeling like they're not doing it up to your standard or that you're judging what they're doing. Again, frame it as a solution to an issue. The parties would benefit from judicial case management to streamline resolution and reduce costs. You're helping opposing counsel help their client. In turn, you're helping yourself and your client. But above all, you are helping the judge. The result of doing these things very strategically is you've just imposed structure in your case. You've exposed gamesmanship if it exists on the other side. Your client is the one that comes across organized and reasonable, and either outcome you get from the judge favors you because you've done everything to protect yourself and protect your client in this situation. So the sequence of these events, I want to emphasize, is not interchangeable. It is very important you do them in order. Hold that line in writing. Document the obstruction. File the RFO asking for structure, not retribution. Again, frame it as a solution. The judge sees a problem solver, not a complainer. You are not avoiding sanctions practice by doing this. You're setting it up properly so that when you do invoke that sanctions practice, the court is ready to grant relief. This works because the bench has changed. Next slide, please. Know your bench. The rules of the game have changed. Newer judges bring criminal, civil, and other backgrounds to the courtroom. They have different civility expectations. I want to walk through this table very quickly and show those cultural shifts in the courtroom. First, posturing signals poor planning. Aggression equals lower skill. That's the SNEC case. You don't want the courts to think you're incompetent because all you do is fight with opposing counsel. Rule compliance is your baseline expectation. Clarity and organization persuade, and sanctions are your last resort tool. Take time to research new judicial officers. Look at their background. Read tentative rulings if your court offers them. The bench will reveal itself, and it's going to give you very good insight on how to move forward with these strategic things you can put in place to streamline your case. Let's tie all of this together. Next slide, please. So the key takeaways, just a quick recap. Civility is not just ethical, it's strategic. It's required by Rule 9.7. You signed an oath when you paid your bar dues this year. Carton and SNEC cases monetize civility, and the bench will reward it with credibility. This is a huge advantage to you, not only for your current case, but all cases in the future. Case management tools give you control. There are family code statutes and rules of court that hand you real authority to structure your chaotic litigation. Next, early mediation frames your case. It does not just settle it. Use it to narrow issues, shape your client's expectations, and prevent predictable crises. Next, help the judge help you. Be on the organized, reasonable side. Overloaded documents, which are in many counties these days, reward clarity and punish chaos. Please be the clear, concise one that is on the judge's good side. Last, don't just react. Proactively structure your case. Every case management order you propose as a 271 motion, you will not need to file it later. You've already laid the groundwork, and opposing counsel will be on board with what you are presenting. They will know of their bad behavior, and if you have to resort to that 271 sanction, you have already done so. Last slide, please. The bottom line, in an era of overloaded dockets and increasingly sophisticated benches, the power move is not aggression, it is strategic professionalism. Remember, civility builds credibility, credibility earns trust, and trust wins cases. That is all for today, but I would love to take your questions.
All right, well, it looks like we have quite a couple questions so far, just to start us off. Do you submit proposed CMO at any stage of the litigation or at only certain phases and matters?
So I recommend that you keep those case management orders as your go-to tool at any stage of litigation. It's very helpful if you can file them at the outset once you get a read on opposing counsel or the case as a whole. A lot of times you don't see the true colors of people until you're down in the trenches months in. So you can really use them at any time. It's very, very important that you are surgical in what you ask for in those case management orders. They are going to be a huge advantage to you at any stage of the litigation. Obviously not a week before trial, but while you're in the trenches on flushing out issues and before you go to any settlement, I highly recommend that you do that, especially before you engage in multiple rounds of discovery.
Okay, thank you. And then I have another one. I like the idea of bifurcation, but when I have it tends to result in a longer fight over property division. Would love to know your thoughts.
So this has not been my experience. As I mentioned when we were on that slide, a lot of times people are very eager just to have status over with. I find that lingering limbo of I'm still married, but we're separated, but not legally separated and not together. It really clouds how people come into what to do with their assets. When they've already bifurcated status, a lot of the stuff you can then explain to the client is just stuff. No one's going to leave this divorce happy. You already have, your new life before you. You're single. Let's move on and just resolve the property disputes. And 9 times out of 10, I have found that that helps with property division and does not hinder it. Your experience may be quite different. If you come across a case, feel free to email me and reach out about. I'm happy to help you craft some language for your client to nip that perception in the bud and help them move towards dividing their property.
All right, thank you. And let's see. Let's see here. Looks like we're. I go ahead and search her. Oh, there is a question. Perfect. All right. When you have opposing counsel not disclosing assets and schedule of assets and debts, then not providing information in response to informal and formal discovery requests when no motion to compel was filed, has had 2 different attorneys. What do you suggest if opposing counsel is not willingly providing information related to workers' comp claims which may have a CP interest, cash out of PTO or other employment, etc.?
Subpoenas. Most of the time you can read early on, just as you have, whether or not opposing counsel is going to be forthcoming with information. A lot of times it's not opposing counsel, it's their clients. Clients who believe that, my husband or wife has no interest in my workman's compensation claim. I'm the one that's injured. I'm the one living with these things. Don't give them any information on that. I had a recent situation with a CalPERS case. Husband's not only getting a pension, but also some sort of disability benefit. His claim, he had no issue with wife taking half of his pension. He wanted her to get none of the disability because he was the injured one. Refused to give any documents. Subpoenas will go a long way. If you then don't get that third-party subpoena response, you have a lot more at your disposal for third-party non-compliance and sanctions. Companies don't want to engage in a litigation fight. They don't want to pay outside counsel to do discovery disputes. Get as much as you can through subpoenas early on. A lot of times I will just do subpoenas for financial documents and information, even if there hasn't been a discovery dispute yet, because I don't know what I don't know until I get the documents. And if I already have a packet from Wells Fargo, for example, and see that the parties had 9 accounts open, but wife only knew of 2 and husband only disclosed 3. One, they may not have been aware of them or they're a signatory on another account, but I have the full picture. Sometimes you will run into roadblocks where husband or wife is on an account with a third party, so the bank will completely redact documents. I had gotten a packet from Wells Fargo where every single item in the file was redacted to the point I had no idea what was going on. But at least I knew there were some accounts there, and I was able to then pinpoint opposing counsel and ultimately get an order from the court where they had to overturn all of those documents. It was innocuous. It was something as simple as a child was on the account and it was actually theirs. But wife refused to turn anything over because she thought she had the advantage in keeping that hidden. And sure enough, there were assets in there that were commingled with son's account that were relevant to the divorce, and I only knew it because of the packet of redacted documents that I got from Wells Fargo. So use your subpoenas as much as you can. That third-party discovery is really, really crucial.
All right, I got another one. How do you handle a judge that tolerates incivility?
You they are not inclined to address those issues. Maybe they were co-counsel with someone who's been practicing in an area for years, or they have a different relationship with some of the attorneys, and it can cloud whether or not, it's not supposed to, but it can cloud whether or not sanctions are granted. Again, you'll find situations where judges are not inclined to order those 271 sanctions to either party just to make it fair and just so they don't have to address it. It does happen. That's why you don't ask for those sanctions at the outset. You do everything possible to make it so that the judge has to order them in the future. It's not discretionary. You have built those CMOs out. You have orders already in place. Then when you show that opposing counsel has violated an order of the court, something that they agreed to do or that the court is telling them they have to do, the court their hands are a little bit more tied to order those sanctions that you're asking for. So if you're very strategic in doing those 4 steps that I laid out for you, if you have to resort to sanctions later on, you are much, much more likely to get them.
All right, and let's see. When you receive communication from opposing counsel loaded with insults directed to you or your client, do you just ignore it or do you make an effort to refute it at all?
Generally do not. There are some really good books that I'm happy to share with anyone if you have a problem with just letting it roll off your back. A lot of times when you respond to those things, it's going to create anxiety for you. One, not only because you're reading these things, you're going to get defensive. What you can fire off can be heat of the moment. Like I said, open that text box, type up your response, save it for yourself, never send it. Let them go. An example, I had put in an email to opposing counsel on a case. Your client's spousal support was delinquent. It had been 4 days past due. I received an email saying, spousal support was received today. Let's say it was day 6. And it was not delinquent. Delinquent means it was never sent. Well, as we all know, delinquent means late. All I did was address that back and say, great, I'm glad it was sent. We can both agree it was a few days late. Please remind your client it's due by this date. I addressed very, very kindly, but not directly, the little dig that I had used something incorrectly, but just let it roll off. Make those correspondence clear and concise. Kill them with kindness. It's the best for you on a personal level, on a professional level, and the judge will look very, very highly upon it.
All right, it looks like we've got one more question. Being new to this area, I have observed opposing counsel submit false statements through ex parte applications that read very persuasively and successfully misled the court. What advice might you offer to address these tactics with the court?
Do a really good job. If you know something is false that's been filed with the court on an ex parte basis, if you get an unfavorable ex parte ruling based on those untruths, you can file your own motion to have those set aside and clear the record. So for example, if they're saying, husband says A, B, C, D, and wife is alienating husband from the children, but you have a completely different story. A lot of times this is where those communications from your client come into play. You'll have a record showing, no, I gave the children, from wife's perspective, I gave the children whenever he asked for them, or I accommodate these calls, or he just never calls. So follow up with your own motion if necessary. First, of course, try to meet and confer with opposing counsel and build the record in writing. Hold that line. Like I said, that's always step 1. Meet and confer, point out the untruths. If you can, correct them with writings that you have, evidence that you have. And if you cannot resolve it, that's when you file your motion asking the court to set it aside and point out all of the error in opposing counsel's ways.
All right, it looks like that's it for questions today. Do you have any other closing statements you'd like to make, Noel?
I would like to again thank the Beverly Hills Bar Association for sponsoring this CLE today and all of you for spending your lunch hour with me. Again, if you have any specific questions come up, today or in the future, feel free to email me. My email address should be on the court materials, but you can also look up Noel Guth on the State Bar website, and I am happy to work with you, answer your questions, send you samples. I believe that we all benefit when we can work together as co-counsel in the field of family law. What makes one of us stronger makes all of us stronger, and it benefits us and our clients. I hope you all have a great afternoon.